of Appeals Division 1 is now in session.
Thank you very much. Please be seated. Thank you. This is the time set for argument in Gersten versus Sun Pain Management. Our cause number is CV150635. Let's begin with introductions of counsel.
Good morning, Trevor Fish, and also have Lee Dowd here representing the appellant, Adam Gersten.
Thank you.
Good morning, Michael Ryan and Carolyn Holden, and we represent appellees, Dr. Burns and Sun Pain Management.
Great, thank you very much. Let me go through a few preliminaries that you, just to make sure we're all on the same page. Each side will have 20 minutes. The appellant may reserve part of that time for rebuttal. And when you go to the podium, if you'd like to reserve time for rebuttal, if you'll let us know, we'll try not to poach on your time, so you will end up with that rebuttal time. We are recording the proceedings today, both audio and video. And so when you go to the podium, if you could please restate your name. That way, if someone listens in, they'll be able to identify the speaker. Let me advise counsel that we have carefully reviewed your briefs. We have reviewed pertinent portions of the record. We're familiar with the argument and the procedural history of this matter. I think with that, we'll go ahead and begin. For the appellant.
Trevor Fish, appearing for the appellant. May it please the court. This case, we believe, is a case of first impression, dealing with a civil lawsuit based upon specific violations of the Arizona Medical Marijuana Act, also may be referred to as the AMMA, or I may just say the medical marijuana, or just the act. Specific violations have been alleged by our client, by Appellant Gersten, including discrimination by a physician of a patient's right under the Act. Appellant Gersten has asserted a private right of action against appellees due to their discriminatory conduct. And that is going to be one of our peremptory issues in this case is, does a private right of action exist? We have listed multiple issues of the issues that are on appeal in this case. I tried to narrow it down a little bit more to the real meat, the meaty issues that are presently before the court. There's, of course, the issue of the motion to dismiss. Was it proper for the trial court to grant dismissal of this case just purely for the fact that it was a 12b6 motion? We weren't into...
Procedurally, why did this get all messed up with findings of fact? And a 12b6 motion, that doesn't apply. Why did you do that?
Why did we request findings of fact? Really to preserve issues on appeal. What's even more odd that we requested findings of fact is that that findings of fact and all those conclusions of law were incorporated by the trial court into their minute entry ruling.
But you kind of opened that door by going down that path, which really is totally inconsistent with 12b6. So what do we do with that? I mean, a lot of times we would send it back to the trial court and say, this should have been converted to motion for summary judgment, do-over.
Yeah. And that might not be the best course of action. I mean, it is important to realize that, of course, this wasn't a summary judgment motion. The findings of fact probably really shouldn't have gotten as detailed. This should have been more conclusions of law. If the court was going to make conclusions of law, great. And I believe that's what we intended more, is for the court to focus on what are the conclusions of law, because that may be more appropriate when considering a 12b6 motion, is purely what are the issues of law in this case. We were a bit surprised, and we're in front of the trial court. That particular judge, we're in front of him all the time, but he left no uncertainty of where he stood as far as where the court felt that the plaintiff's rights, or had a right whether or not to assert a claim under the Medical Marijuana Act. So that is certainly an issue to be addressed, and that's one of my final issues on appeal, is the findings of fact, conclusions of law, was that appropriate, especially since we asserted an objection once we saw the defendants or the
You asked
appellees.
for them. I mean, you didn't just ask for conclusions of law, you asked for findings of fact, and so I have a hard time, but you've got other points to go on to.
So it'd have to be just anything that was undisputed facts. So that's the real issue, is if there's anything that appears disputed, but certainly in this case there are quite a number of facts that are disputed, especially with the exhibits that are attached to the appellee's motion, to the appellee's brief, references made to a contract. I mean, there's even in the minute entry and in the ruling, there's references made to a contract, to all these things that were never even admitted into evidence, never considered, never attached to a motion or response. So that definitely is an issue.
Let me, if I may, I want to use your time wisely, go to the what I consider the meat of this case, which is there a private cause of action? Let's assume for a moment, I believe Sun Pain's doctors are regulated by the Arizona Medical Board. If not, there are other licensing boards. But let's assume that's the board in play here. Under one provision of Title 32, one of the definitions of unprofessional conduct by a doctor that's regulated by the Arizona Medical Board is violating any federal or state laws, rules, or regulations applicable to the practice of medicine. Therefore, let's assume for the moment that, as Mr. Gerson alleged in the complaint, Sun Pain's physicians violated the anti-discrimination provision in the Act. He could file a complaint against the physician with the Arizona Medical Board. Why then do we need to have a private cause of action? Why isn't that avenue and that mechanism good enough?
It's not the proper mechanism for enforcing a statute, a right that's granted by a statute. Going through kind of an administrative process.
Well, what's wrong with it?
Well, because there's still not going to be a court that's going to be able to enter any sort of rulings. That there's going to be, we've asked for injunctive relief, we've asked for declaratory
Well, let's put
relief.
aside the injunctive relief. Let's just put that aside. The issue here under state law is we look at the effects, we look at the purpose, we look at all the the law as well as I do. There's an avenue of relief, which I don't hear you saying there isn't. It would be an administrative disciplinary proceeding. Why isn't that satisfactory to honor or to implement the anti-discrimination provisions of the Act?
Because it's not their, the medical board, I understand that they're going to regulate, the physicians who they license, as any administrative agency would. But when we talk about a private citizen's rights, they're not necessarily there to protect the citizen's right. Yeah, they're going to protect the public, but they're not the proper forum for enforcing a right that's specifically granted under statute. The same comparison needs to be considered with an employment claim.
But let me get back to something you've said a couple of times, which is enforcement. Enforcement is one thing, but a claim for money damages, where can I find in the AMMA any intent to allow a claim for money damages in a private cause of action versus just enforcing don't discriminate against me?
Well, and that would be with enforcing anything is there, and unless
No,
a
I don't
statute.
think it would be. Enforcing is different from getting recompense for an alleged violation.
So the two issues there is, okay, if a statute doesn't specifically say can a plaintiff collect damages, does that mean that they're precluded from doing that? And there's been plenty
but that turns the analysis of private cause of action law 180 degrees. You've got to find an intent somewhere in the Act to authorize a claim. Let's say that we could infer a claim to enforce the non-discrimination provision. Where can we find anything in the AMMA that says you get money if there's a violation?
And that's going to go to, again, whether or not that's included in part of a private right of action. There's plenty of examples of cases where the private right of action isn't specifically stated in the statute, but they're allowed to pursue the claim. We've cited the case, was it the Brewer case, the Chavez Brewer, that dealt more specifically with enforcement.
It dealt only with enforcement. Yeah. They weren't seeking money damages. So give me your best case that shows that over and above enforcement, you also get money damages
Yeah,
as a private cause of action.
I don't know a specific case that deals specifically with that money damages, but that's where we go back to, at least at the very minimum, there's right of enforcement. And that's, again, where if we're going to the medical board, that's not the proper avenue. They're not going to issue damages, and they're not going to enforce. They're not going to do either.
Well, wait. It may, I don't know what is the scope of the medical board's authority. If a physician discriminates against a patient, let's assume there's a violation. And if you don't know the answer, that's fine, because I don't want to have anyone guessing here. But the board what can the board do? Can it sanction the doctor and say you need to pay damages? Can it do that, if you know?
I don't know specifically.
Okay.
If it's like with any other agency, register of contractors, Department of Real Estate, they can issue a fine. But I won't speak because I don't know specifically the medical board. But again, it's not dealing with enforcement of. It's going to deal with that particular doctor. It's not going to be something that's not as effective a forum as going through the courts.
Well, but if you're asking this court to identify an implied cause of action in a statute where recognizing it was an initiative, ballot initiative, but that could have had an express provision, and in fact in some respects does with some regulatory issues, but clearly does not here. So the thought that it might not be as effective as other mechanisms really is far beyond what this court should be considering, isn't it? I mean, isn't that a legislative call, not a judicial call?
Yeah. Well, again, if we look specifically at the statute, that brings up an interesting situation. Are we to look at other forums, other avenues, other mechanisms, or should we just focus on this particular statute? And I think that's what we need to do, is focus on this statute, determine whether or not the right's implied. We can't look to legislative intent. I know that the appellees keep pounding on that, and that's specifically referenced in the trial court ruling, that there's no legislative intent that allows for even to be implied the private right of action. This is a voter initiative, a direct voter initiative, so there is no legislative intent.
Well, but isn't there, following up on what Judge Thomas suggested, obviously the legislature has to enact the statutory scheme to effectuate the voter initiative, and in part in 362818 they did prescribe an enforcement provision. So why isn't that demonstrative of the fact that when they intend to create a private enforcement action, they say so?
But that enforcement isn't dealing with for example, discrimination.
Of course it's not, but it shows that they know how to create a private cause of action in the AMMA when they intend to do so. And if our linchpin is legislative intent, which I think it is, why isn't that important, that they prescribe some enforcement mechanisms but not the kind that you're suggesting?
And that can be considered by the court. That is something to consider because, again, the courts look to the context of the statutes, the language, the subject matter, the effects, the consequences, but also the spirit and the purpose of the law. If we look to the proposed ballot language, it's to protect patients with debilitating medical conditions from criminal and other penalties. So I think we can look at the purpose by looking at that proposed ballot language, by looking at
so your argument would be that what happened here was a penalty?
Correct. It is a penalty against a patient's authorized use of medical marijuana. Because if we look at the statute, it's there for the purpose of medical care.
But just so I understand, and one way to look at this case, and I'm not asking you to agree with this, is that a doctor asked a patient to refrain from certain behavior. The patient said no, and the doctor said that's fine. Consistent with my obligations as a doctor, I'm going to terminate our, doctor-patient relationship. Your argument is that that's a penalty.
That is penalty, and that's one of our alternative arguments. That's a penalty, but also discrimination. That there was discrimination. It wasn't saying that there was a valid reason, and this is part of the issues of fact that never got into. Was there a valid reason for the medical provider to say you need to stop medical marijuana use?
And I understand that point, although that assumes, does it not, that there is a private cause of action here. If there isn't a private cause of action, we never get to that more granular question.
Correct. And that's what you're dealing with, is a physician that has just a blanket all of a sudden policy, if you're using medical marijuana, stop or you're discharged. I mean, it's one of those situations where I keep bringing up the employment arena because the employment is referenced in the statute as well. But it's like terminating an employee. You can terminate an employee with cause, without cause, but you just can't have bad cause. And that's what this situation was, is the patients are being discharged, the patients are being terminated for bad cause. There was no finding of, hey, for your particular treatment, we believe that it's going to impair or lessen the effects, or it could be, you know.
You're not arguing a sort of wagon seller type private cause of action under Arizona's common law. I don't hear you arguing that at all. You're arguing that there's an implied cause of action pursuant to a ballot initiative that resulted in the statute. Those are very different sort of origins, aren't they?
Yeah. Well, I think we've made both of those arguments because we have cited the wagon seller case, that this is, if not an explicit or express private right of action, at least an implied right of action.
But if wagon seller was not, and it's been a while since I've read it, but that had nothing to do with an implied cause of action in a statute, did it?
No, and usually I'm quoting wagon seller for other issues. You know, it's attorney's fees or other issues. So I'm not recalling that specifically to mind as to how they dealt with the implied right of action.
I had thought it was common law, and in fact it was somewhat displaced by a statute that was enacted as a result of wagon seller.
Yeah. Well, and then if we're dealing with common law, that's where we kind of come into the declaratory relief, injunctive relief. Can a court do that? Can a court issues those type of relief? The private right of action is going to go to our claim of a breach or violation of the statute. You know, is there discriminatory conduct? But we also need to analyze, and we brought this up at the trial court level, if it's determined there is no private right of action whatsoever from this statute, then even the specific provision in there where it talks about how an employer, you know, may not discriminate against, you know, a person, the hiring, terminating, imposing of employment, you know, or otherwise penalize the person. So if this court in this case finds that there's no private action for, you know, medical marijuana use by doctor-patient, then it's also finding there's no...
No, I'm sorry, I don't agree with that, and I'll tell you why. I asked you at the beginning of the argument about whether there is a mechanism for enforcement of this right with the Arizona Medical Board or other licensing boards of physicians in this state. I don't know of any analogous board involving employees. So I don't think the fact that, let's say hypothetically, or let's assume for the moment, we reject the argument that there's no private cause of action, that does not necessarily mean that the protections afforded to employees or tenants, as I recall, the other two sections, they may well have a private right of action. That's a different kettle of fish, and I don't think one forecloses the other.
Well, if we're saying that there's no private right of action as a result of this statute, then that's where it's the slippery slope. Where I think if you read into it, yes, there's an implied right of action by an employer, implied right of action by a tenant, implied right of action by anyone that's using it for the purposes of medical care. So a patient, a doctor-patient situation. There's the Department of Labor, and I don't deal with those type of cases, but I know the Department of Labor, when there's wrongful withholding of wages, that's something to go before the administrative agency, and the employer is brought in that circumstance. So there's other administrative agencies for that issue. I just think that would be... it's not the best mechanism. It's not the best avenue for, you know, enforcement of a statute, especially when a specific right is granted to the public through this statute.
It may not be the best way, but you know, you relied on the restatement test, which I believe is quite different from the test we apply in Arizona. And if you look at McNamara, it's not a question of what would best effectuate the Act's spirit and purpose. It's what was the legislative intent. And we only look to spirit and purpose to determine legislative intent. We don't, as a different branch of government, say it really would have been a better act had they put this provision in. It would have been more fair. It would have provided more rights. That's not our role. It's more limited. So when you say...
And that's the situation when we have a direct voter initiative where there's not a lot of the legislative intent to look at. I'm down to 2.5 minutes. I'd like to reserve that for rebuttal, if I may. Thank you.
Good morning. Michael Ryan on behalf of appellees. The issue in this case, the overriding issue is whether a permissive user of medical marijuana in the state of Arizona can dictate the medical judgment of a physician.
Before we get there, this record is very confusing. I want to be clear about this. Is it your position this is an appeal from an order dismissing the complaint for 12B6 reasons, failure to state a claim?
That's correct.
Okay. Then, do you agree that your client did not provide any evidentiary support for most of its factual allegations? I don't think it provided any. I don't see any affidavit. I don't see any verification. I don't see any depositions. I don't see squat. That's a legal term, okay?
Exactly,
Okay.
squat, yes.
So without then that background, then all of those findings that the court made, the factual findings that the court made, unless they relied on Mr. Gersten's verified complaint, fall by the wayside. We now can ignore them. Is that correct?
That is absolutely correct. Judge Norris, this case and this decision does not rely on facts. It
Except
relies
where
on
you
the
just
law.
started your
Yes,
argument
exactly.
seemed like it was going there, because you
Yes.
were talking about medical judgment and all, and that would be for summary judgment if it got past the private cause of action issue.
The way I started my argument is to simply say the policy. And the policy, here in the complaint, we know that it is conceded Dr. Burns and Sun Pain Management were prescribing Demerol to the appellant. And it is conceded, it is undisputed, that he was to only get his pain management through our facility.
Where's the facts of that?
He admitted it in his brief.
No, I'm sorry. Briefs are argument. Where is the factual support for that statement? This is the problem I personally am having with this case, is that it's as if both sides decided to try and mushroom this into something else, but now neither one of you want to have the consequences of that. If this is a true motion to dismiss based on 12B6, you take the well-pled factual allegations, not the legal conclusions, you accept them as true. He says that he was discharged as a patient because he was taking medical marijuana. I don't believe there is anything in the complaint about contracts or anything else or other reasons. So if we stay within that complaint, that's where we need to stay.
Understood. He did, however, Your Honor, and I agree with the court, he did, however, say that he was using Demerol. And the use of Demerol and medical marijuana was not accepted by our client. That's in the complaint. And that he was discharged as a patient. So going, I think, to the most important issue to this court, and that is there a private right of action under the AMMA? Judge Norris, you're exactly correct. The Arizona Medical Board has the authority to discipline any physician for a violation of federal or state law, which would include the AMMA. The AMMA is state law. And if there is discrimination that is felt to have occurred, the mechanism, by the way, which is much speedier than the courts, is to file a complaint. And in 21 days, the physician has to respond to that complaint. And then they have at their next meeting, they go over it, they investigate it, and they reach a conclusion as to whether, in fact, there was a violation. If there was, then there is the ability to discipline that physician for violating that provision.
Is there a way to, it's kind of an odd situation where a patient would want to be back with the physician who has discharged them, but is there a way to enforce that result at the board level to reverse the discrimination if they find it?
Well, and I think that, Judge Downey, that's why I actually started, that's where I was headed with my opening argument, is that, you know, it's a question of whether a physician has the right to exercise the medical judgment to terminate a patient. And if, in fact, the medical board were to find, which honestly, this is, I can't speak for the medical board, but I've appeared before them numerous times. And What they are concerned about is adverse reactions between medication and improper prescribing practices. Every time I go there, there are issues relating to whether somebody is becoming addicted to medication. So I think they would probably not force a physician to prescribe Demerol to a patient who is receiving marijuana. And after all, that's what this whole complaint has asked for this court to do.
But let's take these facts out for a minute and have a hypothetical. Let's say we have a doctor who says, I will not accept any patient who is on medical marijuana, period. And a complaint were filed with the medical board, and the medical board said that's a violation of the AMMA. Then what could the board do to enforce the AMMA?
The board,
patient?
And that's an excellent question, Judge Downey. The board could issue discipline to that particular patient. But if the court is asking me, could they issue some kind of a mandate to their to the other physicians, they couldn't do that, but neither can a superior court in a private right of action. That's decided simply upon the whether there's discrimination, and then money damages are awarded.
Counsel, let me ask you the flip side of Judge Downey's hypothetical. What if the board found that was not improper conduct, decided not to impose discipline on the doctor's license? What remedy or relief or options would the patient then have, recognizing the patient, I suppose, is the complainant, but is not a technical party in that discipline proceeding, perhaps?
The option the patient would have is to appeal that.
Is the patient a party to medical board?
The patient can appeal the decision of the medical board to the medical board, not to the court.
Got it.
So that they appeal the decision, and then the medical board again reviews whatever the appeal is, and then makes a decision as to whether there's the ability to sustain the appeal or not.
And is there any route then for a dissatisfied patient, if they remain dissatisfied at that level, to seek judicial review?
Not to my knowledge. I do not believe the patient can. The doctor can if the doctor is disciplined, but the patient does not have any route to seek judicial review. However, as is pointed out, the patient has other non-judicial routes, and those are being used all the time to go to the legislature, through the voting process, through even going to the Arizona Department of Health and asking for certain regulations to be passed. There are many legislative things that can be done. The kind of the gravamen of the entire thing, though, is that the McNamara decision is a very important decision, because it recognizes if, in fact, there is a remedy provided in a statute, then the court is not to take it upon itself to try to improve that remedy, to augment it, or to change it.
Although, to be fair, in McNamara, the electors who were appealing did have a very tepid remedy themselves under the statute that we were construing here. There's a remedy not for patients like Mr. Gersten. So as much as I like the McNamara opinion, I think it's probably one of the best the court's ever issued, I'm not sure it gets you exactly where you want to go.
I would argue, Judge Downey, that it's more analogous, because this is the thing. The legislature clearly put a remedy of a mandamus action if the health department didn't develop and pass regulations for the AMMA. So that is a remedy in the statute.
Well, to be fair, I mean, you cannot strip the mandamus provision of the statute and take it and look at it in isolation. It was clear that it was tied to the registration requirements, the certification requirements, the regulation of growers, the regulation of sellers. And so that was a regulatory scheme that was envisioned through a mandamus action. I don't think it's fair to say, and I think it would be a stretch to say, that statute was also designed to allow someone like Mr. Gersten to go to the health, to the Department of Health and say, oh, pass a regulation barring discrimination. The language just doesn't, is not, I don't think, you cannot stretch that out.
Well, I would agree in isolation, Judge Norris, that that's correct. But what else do we have? We have silence, absolute radio silence in the discrimination portion of the Act of any private right of action.
Supreme Court said in Napier, when there is that type of silence, that's not the end point, that's the beginning point.
Absolutely.
And then you go and look at the language of the statute, the context, subject matter, effects and consequences, spirit and purpose. That's what we look at.
Yes.
And I think it's fair to say, whether we like the act or not, the voters adopted findings that the act was designed to protect and bar penalties. So, I mean, it has a very broad purpose. So it seems like, with that in mind, how do we square not implying a cause of action, given the overwhelming clarity of the act and its findings and its provisions that were designed to protect people who are certified or registered users of medical marijuana?
I agree, and we've said all along, and we tried to be clear on this, that it's the threshold determination of whether the legislature was said it or not. If they didn't expressly say it, it doesn't mean that we don't go further. So we have that, and so I kind of backed into it. So let me go frontwards now. We have that. We know it's silent. And so then, in addition to that, we have the mandamus provision by the legislature. Nothing in the discrimination portion, but we have the mandamus provision. That provides a remedy, whether it's exactly attached to the discrimination portion of the Act is of no concern. It's a piece in the puzzle.
Isn't that where McNamara does help you? Because
Yes.
the title of that statute is enforcement of this act, and McNamara says, in a different context, the legislature obviously knows how to provide for private rights of action in the campaign finance context when it chooses to do so. And so I'm interpreting your argument as saying, yes, 3628.18 doesn't deal with this specific situation, but it shows that within the AMMA, when there's intended to be an enforcement action, it says so. Is that where you're going with
Absolutely. That's exactly where I'm going. And so that's another piece to show that the legislature did not intend to provide a private right of action to be filed in court for the discrimination portion of the Act. There are other avenues, and we've talked about them, the Arizona Medical Board. Then that brings us, I think, to a very important issue, and that is the conflict with federal law, because there is a conflict with federal law. The Controlled Substances Act preempts anything that state law could do. And physicians, by the mere prescription,
But forgive me, Mr. Gersten sued Sun Payne and Dr. Burns not because they refused to prescribe. We're
Right.
not dealing with a prescription case at all. What we're dealing with is, I will not treat you solely because you're using medical marijuana. It is, therefore, there is no direct conflict with federal law because your clients are not being asked to prescribe or certify.
Your Honor, you're exactly correct in this case. But
That's
what appellant is asking this court to do is not just find a private right of action for this case, but find a private right of action in total under the AMMA.
We don't have to go there. This case squarely does not involve prescriptions. That's a whole other matter, and it's not presented as, the only issue here is whether under the AMA can a plaintiff sue a physician for violating the anti-discrimination provisions, which is turning away from medical care, not prescribing medical care. That issue is just not in this case.
Understood. And the reason that we raised it was to go to the global issue of whether, in fact, there is a private right of action, whether the legislature would have intended to put Arizona physicians in that uncompromising position of being between a rock and a hard place.
But the anti-discrimination does not require an Arizona physician to treat, in a sense of prescribing medical marijuana. Indeed, it uses the words, "it shall not otherwise disqualify a registered qualifying patient from medical care." It
Right.
just says, you shall not turn them away, essentially. Doesn't mean you have to prescribe marijuana.
And that's actually a perfect segue into where I want to go last, and that is, what do we have here? We have Demerol and we have marijuana. And the termination of Mr. Gersten as a patient was as a result of his obtaining marijuana somewhere outside of Sun Pain Management and using it in conjunction with the Demerol. That's the termination, okay? Now, that could have been any medication. It didn't need to be marijuana. It could have been he could have got morphine from another provider, and the same result would have occurred.
And counsel, I understand that, but I don't think we'd be here if that was the fact pattern.
Right, you're exactly right. We wouldn't be, and that's the point. The point is that is this really discrimination
Well,
at all?
and I understand that, but I don't think, we're here in the context of a very specific provision with respect to discrimination that deals with, the AMMA. It's not, using prescription drug A and prescription drug B, and you can't discriminate users of prescription drug B, because use of marijuana, as you know, under the AMMA is not a prescription. It's
Right.
different than that.
Mm,
So I
absolutely.
understand what you're saying, but I'm not sure it has traction in this context, given where this case is and given the nature of the claim.
Understood. It simply it goes to magnify the, I guess, can of worms, for lack of better term, that this court would be opening if it found a private right of action in this case. Because this case, although we're isolating to its own facts, will not be isolated to its own facts by litigants.
And I understand that, but isn't that always the case even when a court recognizes that there's an implied cause of action in a statutory provision? It's not an implied, for example, Consumer Fraud Act. That's not, all things and every. You still have to fall within the ambit of the statute. And if this court were to recognize a private cause of action, it wouldn't be for all things AMMA. It would be for this specific provision. Fair?
Yeah, it would be according to what this court holds. And then, of course, the arguments would fly after that.
And I understand there might be dominoes that would fall if this court went that way, but just the way it works, courts
Yes.
are always asked to address the specific claim as opposed to the broad.
No question about it. You're correct, Judge Stone. Now, the last thing that I wanted to address before I run out of time is just to ask this court, do I need to talk about the injunction? Do I need to talk about the declaratory relief action? And I see a shake of the head, and I will take that as a no.
You
And
briefed it very well, and I think we understand the issues.
excellent. Thank you very much.
And I'm not going to speak as to the injunction or declaratory relief.
You briefed it very well.
That's been in the briefs. I did want to just touch lightly or briefly on the federal preemption issue. Federal preemption was mentioned in the appellee's briefs. I hear today it mentioned as instead of federal preemption, a conflict with federal law. There was no preemption. Conflict, perhaps, but not in this case, maybe in some other future case. We don't know. There was no factual issues as to prescriptions and whether or not the Demerol use with marijuana, there was a negative effect. There was nothing presented as to whether or not that's true. I don't believe that Demerol was even referenced in our complaint. So the federal...
Actually, I just looked and it was.
It is referenced? Okay. Well, certainly there's nothing addressing whether or not the use of Demerol with medical marijuana, if that has a negative effect. That wasn't presented in this case. So let's focus on, specifically, is there a private right of action? I think Judge Downey had mentioned about, it might have been the McNamara case that you referenced, a tepid remedy. Certainly, the reference to the other statute of enforcement, 362818, when we're talking about the Department of Health, that a citizen can commence a mandamus action against the department if they fail to take action that's mandated under this chapter. That provides no remedy to my client, to the appellant in this case. There's nothing there that references.
Well, that's true, but I think the point is this, is that it does show that when the voters acting in their legislative capacity, or majority of the voters acting in their legislative capacity, they knew how to provide for a cause of action. And thus, the fact that they did it here, but not here, is undercuts the argument that we, as courts, should imply the cause of action. Because they know how to do it, they just didn't do it.
And it would be part of the analysis, certainly not the end-all. Again, that would be something to take into consideration. I felt...
Need to rush. Tell you what if because this is important, why don't you take another minute
Okay.
and kind of finish your point and then wrap up.
Okay. And I did want to reference a case that was published just this year, 2016, and I didn't have a chance to put it in our briefs. It really just deals, again, about what may be considered.
And what's the case?
It is State v. Turner. It's a criminal case, but it does reference.
And do you have
let me
the
give you the
site?
two. Yeah, State v. Turner, 239, Arizona 390. And that's a Court of Appeals, Division 1. That referenced, specifically, it cited another case, along the Napier logic of what may be considered. They specifically state that, this court stated we may also consider a title to aid in interpretation. So when we're looking at the title, again, that's why I keep hitting the discrimination prohibited. We can't use a mandamus action against the Department of Health to prevent or prohibit discrimination.
But the title kind of hurts you because it's not just called mandamus, it's called enforcement of act.
And I'm looking at the 2813 when I'm referencing the title of discrimination prohibited.
Yeah, it helps you on that one, but it doesn't help you on 362818, enforcement of this act.
But again, it's something that take into consideration. I'm just concerned that we leave no remedy to the citizens, to the public, that this is hearing about, like, the medical board and their enforcement, their procedure. There's no patient judicial review. We're hearing the argument, and we were kind of talking that really is like the chicken guarding the hen house.
Let me ask you, though, there is an analytical framework that this court and the Supreme Court has set forth to determine when private causes of action should be implied when a statute doesn't contain one. And the statute containing one, when one exists, is by far the vast majority. I mean, that's candidly how it typically works. This is an exceptional case, given that. But you're not arguing, are you, that every right in every statute or regulation has a corresponding remedy?
No, I wouldn't argue that, especially with how many statutes we have, how many rights are granted. That would be certainly not a defensible position to take. But for this, when we look at this, not even the entire act, if we're not looking at each specific statute on the act, but if we look at the big, the meaty provisions of the act, the discrimination being prohibited, certainly that is something that I would say that protection of tenants, protection of employees, protection of the patient, that is something that does need to be enforced. So that's where we have the implied private right of action. Unless there's anything further from the court.
Well, thank you very much. And
Thank
I'd like
you.
to thank counsel for their argument and your patience with all the questions we asked. We appreciate it very much. We'll take this matter under advisement. We will issue a decision in due course. Thank you.